Legal and Privacy Brief for February 27, 2026. A $240M Truist Bank class action settlement resolves Georgia overdraft fee claims. Epic urges the FTC to crack down on hidden surveillance pricing. The Supreme Court rules on criminal defendants' rights to discuss testimony with counsel during overnight recesses. Federal law enforcement faces setbacks as DOJ dismisses cases after sworn testimony contradicts evidence. Spain's DPA fines Iberdrola Euros 1M for weak identity verification systems. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, February 27, 2026. Next section, Enforcement Actions. Spanish DPA fines Iberdrola Euros 1M for security failures. Case No. Exp 202,406,239. Spain's Data Protection Agency fined electricity supplier Iberdrola clients Euros 1 million for failing to implement adequate security measures in its telephone identity verification system. The controller's authentication protocol relied on static personal data that was not secret and could be known or deduced by third parties, allowing unauthorized changes to customer contact details. The DPA found the controller violated Article 32 GDPR because it failed to implement technical and organizational measures appropriate to the risk and could not demonstrate compliance with the accountability principle under Article 5, 2, and Article 24 GDPR. Compliance action: review all telephone authentication systems. Replace static personal data verification with dynamic authentication methods. Implement traceable documentation of verification steps. Ensure customer service database updates are logged with verification audit trails. Source: GDP Rub Exp 202,406,239. Croatian DPA fines hospital Euros 3,000 for data breach failures. Croatia's Personal Data Protection Agency fined a hospital Euros 3,000 for failing to provide proper privacy notices, implement adequate security measures, and notify the DPA and affected data subject after health data were disclosed to the media. An employee photographed a patient's medical report and shared it externally. The controller violated Article 13 GDPR by failing to provide mandatory processing information for several years. Article 32 GDPR by not implementing appropriate safeguards for health data. Article 33 GDPR by failing to notify within 72 hours. And Article 34, 1, GDPR by not informing the data subject without undue delay. Compliance action: publish complete Article 13 GDPR privacy notices on websites. Implement formal breach assessment procedures. Establish 72-hour notification protocols for reportable incidents. Train staff that unauthorized disclosures constitute personal data breaches regardless of criminal prosecution. Source: GDP Rub Azap, Croatia. Greek court sentences Intelexa executives to 8 years for spyware scandal, and Athens misdemeanor court sentenced Intelexa consortium founder Tal Dilian and 3 associates to more than 126 years in prison. Reduced to 8 years under Greek law for their role in a spyware scandal involving the Predator surveillance tool. The defendants were found guilty of unlawful access to private communication systems and violations of privacy and data laws after Predator was used to spy on more than 90 Greeks from 2020-2021, including journalists, opposition politicians, government ministers, intelligence operatives, and prosecutors. The court ruled that prosecutors must open an inquiry into whether more serious espionage charges are warranted. Sentences will be appealed, and defendants remain free pending appeal. Compliance action: vendors selling surveillance or security monitoring tools should review compliance with national wiretapping and privacy laws in all jurisdictions where products are deployed. Document lawful purpose requirements for all customers. Implement Know Your Customer due diligence for surveillance technology sales. Source: The Record. Next section, Litigation Updates. $240M Truist Bank overdraft settlement by Kerstaff v. Sun Trust Bank, case no. 10 EV 010485, Truist Bank, formerly Sun Trust Bank, agreed to a $240 million class action settlement to resolve claims it charged illegal overdraft fees on ATM and debit card transactions between July 12, 2006, and April 15, 2014. Plaintiffs alleged the fees violated Georgia's usury laws, which limit the amount of interest a lender may charge. The settlement covers Georgia citizens who had Sun Trust accounts not closed before June 1, 2010, and who paid overdraft fees of $500 or less on ATM or debit card transactions without receiving refunds. Class members are estimated to receive between $5 and $1,000. The final approval hearing is scheduled for May 26, 2026. Exclusion and objection deadline is April 20, 2026. Claim form deadline is estimated for August 2026. Source: Top Class Actions. Supreme Court rules on attorney-client discussions during testimony, Villarreal v. Texas. The Supreme Court ruled unanimously that trial courts may prohibit criminal defendants and their lawyers from discussing ongoing testimony during overnight recesses, except when incidental to trial strategy or plea discussions. Justice Ketanji Brown Jackson wrote for the court that the Sixth Amendment does not permit managing or coaching future testimony, but defendants retain unrestricted access to advice about trial strategy, factual information needed for defense decisions, and whether to accept plea bargains. The ruling balances a defendant's right to advice of counsel unrestricted by judicial interference against a witness's responsibility to offer sworn testimony uninfluenced by a lawyer's midstream tinkering. Source: Scadu S. blog. 10th Circuit reverses dismissal in protest device search case, Armendariz v. City of Colorado Springs, the U.S. Court of Appeals for the 10th Circuit reversed a district court's dismissal of Fourth Amendment claims challenging sweeping warrants to search a protester's devices and a nonprofit's social media data. Colorado Springs police obtained warrants after a 2021 housing protest to search all photos, videos, emails, text messages, and location data from protester Jacqueline Armendariz Unzueta over a 2-month period, plus an unlimited time search for 26 keywords including bike, assault, celebration, and right, in connection with an alleged simple assault. The 10th Circuit held the warrants were overbroad and lacked particularity, and the officers were not entitled to qualified immunity because they violated clearly established law. Compliance action. Law enforcement agencies should limit device search warrants to specific timeframes and keywords directly connected to alleged crimes. Avoid overbroad keyword lists that sweep up years of private communications. Document particularized probable cause for each category of data sought. Sources: EFF. Meta class action alleges $500M stock pump and dump scheme, Irving v. Meta Platforms, case no. 26 CV 1127. A class action filed in California federal court accuses Meta of enabling, facilitating, and materially contributing to a stock manipulation scheme that used scam ads on Facebook, Instagram, and WhatsApp to defraud victims. Plaintiffs claim Meta's advertising tools were exploited by scammers to create and disseminate fraudulent investment ads targeting specific user groups, luring victims into a pump and dump scheme involving Chinese stock Jayud Global Logistics Limited. JID. The lawsuit seeks certification of a class covering anyone who invested in JYD between March 21, 2025 and April 2, 2025 as a result of fraudulent advertisements and suffered losses. Source: Top Class Actions. Federal judge blocks DOJ search of reporters' devices, cites Privacy Protection Act violation U.S. Magistrate Judge William Porter rescinded portions of a warrant authorizing the FBI to search Washington Post reporter Hannah Nathanson's devices, ruling that the DOJ failed to identify or analyze the Privacy Protection Act of 1980, 42 U.S.C. Section 2000 et sec. In its warrant application, the FBI conducted a pre-dawn raid on Nathanson's home and seized 2 laptops, a phone, a hard drive, a recording device, and a Garmin watch in connection with a prosecution of government contractor Aurelio Perez Lugans. Judge Porter noted that lawyers at the highest levels of DOJ, including the Principal Deputy Assistant Attorney General, participated in calls about the warrant, but none identified the PPA as controlling authority. The judge stated this omission seriously undermined the court's confidence in the government's disclosures. Compliance action. Federal prosecutors seeking search warrants for journalists' materials must identify and analyze the Privacy Protection Act's restrictions. Law enforcement agencies should implement review procedures to ensure statutory protections for members of the press are not overlooked in warrant applications. Source: TechDirt. DOJ dismisses assault charges after officer's testimony, contradicts evidence Minneapolis federal prosecutors dismissed felony assault charges against 2 Venezuelan men after newly discovered evidence was materially inconsistent with the complaint affidavit. Officers claimed the men violently beat an ICE officer with a snow shovel and broom handle on January 14, but videos revealed sworn testimony by 2 separate officers was untrue. ICE Director Todd Lyons opened an investigation after the contradictions emerged. This marks the latest in a series of failed prosecutions where federal officers' testimony has been contradicted by evidence, contributing to grand jury refusals to indict and case dismissals. Source: TechDirt. Next section: Regulatory guidance. Epic and groups urge FTC to crack down on hidden surveillance pricing. Epic joined national consumer protection and privacy groups urging the Federal Trade Commission to initiate rulemaking requiring companies to disclose when they use surveillance pricing. The coalition called for transparency rules that would require companies to tell consumers when personal data is being used to adjust prices or personalize offers. This follows growing concerns about algorithmic pricing systems that use browsing history, location data, purchase patterns, and demographic information to set individualized prices. Compliance action. E-commerce and retail companies using dynamic pricing algorithms should document data sources used in pricing decisions. Prepare for potential FTC disclosure requirements about surveillance-based pricing practices. Review whether pricing systems create discriminatory outcomes based on protected characteristics. Source: Epic. Epic urges HUD to rescind disparate impact rule withdrawal. Epic submitted comments on February 13, calling on HUD to withdraw its notice of proposed rulemaking that would completely remove HUD's discriminatory effects regulation under the Fair Housing Act. Epic argued the disparate impact rule is critical to address facially neutral policies and practices that result in discrimination. The proposed withdrawal would leave core questions regarding the disparate impact standard to the courts, removing regulatory clarity for housing providers and enforcement agencies. Compliance action. Housing providers and lenders should maintain disparate impact analysis procedures regardless of regulatory changes. Document that policies and practices with disproportionate effects on protected classes are justified by legitimate business necessity. Monitor court decisions as HUD shifts enforcement interpretation to judicial precedent. Source: Epic. UK government reduces vulnerability fix times with automated scanning. The UK Department for Science, Innovation and Technology announced its vulnerability monitoring service has reduced the median time to fix critical domain-related weaknesses in the public sector from 50 days to 8 days. The service continuously scans internet-facing systems used by approximately 6,000 public bodies for known security vulnerabilities, processing and resolving about 400 confirmed vulnerabilities monthly. The median time to fix other cyber vulnerabilities dropped from 53 days to 32 days, and the backlog of unresolved critical flaws has been cut by 3/4. Compliance action. Government agencies and critical infrastructure operators should implement continuous vulnerability scanning for internet-facing systems. Establish remediation SLAs of 8 days for critical domain vulnerabilities and 32 days for other weaknesses. Track backlog reduction metrics to demonstrate improved security posture. Source: the record. Next section, privacy developments. DHS Save tool makes persistent errors flagging citizens as non-citizens the Department of Homeland Security's systematic alien verification for entitlements. Save tool, expanded to verify voters' citizenship status, has made widespread errors by misidentifying naturalized citizens as non-citizens. In Boone County, Missouri, more than half of 74 flagged voters were actually citizens, including one registered at his naturalization ceremony. DHS has had to correct information provided to at least 5 states. The tool was rushed into use while still adding data, and before it could discern voters' most up-to-date citizenship information. Missouri officials directed county administrators to make flagged voters temporarily unable to vote before attempting to confirm the determinations. Texas identified at least 87 voters across 29 counties mistakenly flagged as non-citizens. Compliance action. Election administrators should independently verify saved determinations before removing voters from rolls or restricting voting access. Implement safeguards requiring manual review of citizenship status for voters flagged by automated systems. Document verification procedures to demonstrate due process protections. Source: TechDirt. Austrian court rules prison doctor not a controller for ombudsman disclosures. BVWGW 221, 2,273,829-1. Austria's Federal Administrative Court held that a prison doctor who disclosed a data subject's health information in response to an ombudsman inquiry was not a controller under Article 4.7 GDPR because the prison governor, as the prison authority, determined the purposes and means of processing. The court dismissed a complaint filed against the doctor individually, holding that when a complaint clearly targets a person who is not the controller for the processing, the DPA must dismiss the complaint under national law, Section 24(2) DSG. The decision clarifies that employees acting on instructions are not controllers for disclosures made on behalf of their employer. Source: GDP Rube. Czech Supreme Court rules access request refusal is reviewable decision. NSS 4 as 246/2020-27. The Czech Supreme Administrative Court held that a controller's written refusal of an access request under national law qualifies as a reviewable decision, and that a complaint to the DPA is not a mandatory remedy before going to court. The controller, the Czech Police Directorate of the Alien Police Service, refused to provide information about which EU member state considered the data subject a threat and on what grounds. The Supreme Administrative Court held that a written reply under Section 34 of the Czech Act on the Processing of Personal Data met the definition of a decision because the law regulated the procedure, imposed a deadline, required written notification and reasoning, and obliged the authority to keep records. Compliance action. EU data controllers should treat Article 15 GDPR access request refusals as formal administrative decisions subject to judicial review. Provide detailed reasoning for refusals. Document the decision-making procedure. Inform data subjects of available legal remedies, including direct access to courts where national law permits. Source: GDP Rube. Reddit fined £14M by UK ICO for age verification. Failures. The UK Information Commissioner's Office fined Reddit £14 million for failing to implement adequate age verification checks. The enforcement action addresses concerns that Reddit's platform failed to prevent children from accessing age-restricted content and did not properly verify the ages of users creating accounts. The fine reflects the ICO's assessment that Reddit did not take reasonable steps to ensure compliance with child safety requirements under UK data protection law. Compliance action. Social media platforms and online services with age-restricted content should implement robust age verification mechanisms. Review age estimation and verification technologies. Document age verification procedures and exception handling. Prepare for regulatory scrutiny of child safety measures in the UK and EU. Source: TechDirt. Next section, policy changes. Trump administration requests Supreme Court stay on Syrian TPS program. The Trump administration asked the Supreme Court to freeze a federal district court ruling that indefinitely postpones termination of temporary protected status, TPS, for Syrian nationals. DHS Secretary Kristi Noem terminated Syria's TPS designation in September 2025, effective November 21, 2025, citing the new Syrian government's efforts to move towards stable governance. A group of Syrian nationals challenged the termination in New York federal court, arguing the decision violated the Administrative Procedure Act because it was made prior to consulting appropriate executive agencies and without regard to Syria's dire country conditions. U.S. District Judge Catherine Polk-Fela issued an order on November 19 blocking the termination. The Second Circuit declined to stay the ruling, noting the Supreme Court's earlier stay orders in Venezuelan TPS cases contained no explanation and involved different factual circumstances. Source: Skadu S. blog. Sen. Wyden blocks Rudd confirmation for NSA and Cyber Command. Sen. Ron Wyden pledged to block a vote confirming LT. Gen. Joshua Rudd as head of both U.S. Cyber Command and the National Security Agency, citing his lack of digital warfare and intelligence experience. Wyden stated Rudd does not have the background that would allow him to immediately step into the role, and opposed the nomination due to vague answers about NSA surveillance authorities provided to the Intelligence Committee. Wyden's blockade means the Senate may need to hold a formal vote on the nomination instead of approving it by unanimous consent. Both organizations have been without a permanent chief for nearly a year since President Trump fired Gen. Timothy Haw. Source: The Record. FCC Chair Carr launches Pledge America campaign demanding pro-America programming. FCC Chairman Brendan Carr announced a Pledge America campaign requiring U.S. broadcasters to air patriotic, pro-America content through the summer ahead of the country's 250th birthday on July 4th. The campaign, framed as voluntary, specifically targets broadcasters operating under FCC public interest obligations tied to use of publicly owned airwaves. FCC Commissioner Ana Gomez and consumer advocates warned the initiative creates a chilling effect given Carr's recent pattern of launching investigations into media companies critical of the administration. Critics note the campaign's limitation to broadcasters suggests an attempt to abuse the FCC's public interest standard control over airwave licenses. Compliance action. Broadcast licensees should document editorial independence and First Amendment protections for programming decisions. Review FCC public interest obligations, but resist content directives that compel specific viewpoints. Consult First Amendment counsel if FCC initiates investigations based on programming content choices. Source: TechDirt. Former Air Force officer arrested for training Chinese military pilots. Federal prosecutors arrested Gerald Eddie Brown, 65, a decorated former U.S. Air Force officer, for conspiring to provide combat aircraft training to Chinese Air Force pilots in violation of international traffic in arms regulations. Brown negotiated a contract through Stephen Su Bin, a Chinese national who pled guilty in 2016 to hacking a U.S. defense contractor and stealing sensitive military data for the Chinese government. Brown traveled to China in December 2023 and stayed until February 2026. He lacked a State Department license to share his expertise with a foreign military. Brown spent 24 years in the Air Force, leaving in 1996 as a major after leading units responsible for nuclear weapons delivery systems. Compliance action. Defense contractors and military training providers must obtain State Department licenses under ITAR before providing any training or technical assistance to foreign militaries. Former military personnel with specialized expertise should consult ITAR counsel before accepting international consulting engagements. Document all foreign government contacts and proposed activities. Source: The Record. Google disrupts China-linked cyber-espionage campaign. UNC 2814 Google disrupted a long-running China-linked cyber-espionage campaign targeting telecommunications providers and government organizations across at least 53 organizations in 42 countries. The group, tracked as UNC 2814, has been active since at least 2017 and used a newly identified backdoor called GridTide that abused legitimate Google Sheets functionality to conceal command and control communications. In at least one case, GridTide was installed on systems containing sensitive personal information, including names, phone numbers, dates and places of birth, and national or voter identification numbers. Google said UNC 2814 is distinct from Salt Typhoon and targets different victims using different methods. Compliance action. Telecommunications providers and government agencies should monitor for unusual cloud spreadsheet API activity. Review network segmentation between systems containing subscriber data and internet-facing infrastructure. Implement application allow listing to prevent unauthorized use of cloud services for command and control. Coordinate with threat intelligence providers to obtain UNC 2814 indicators of compromise. Sources: The Record. Next section, compliance takeaways. Strengthen authentication systems. Spain's Euros 1M fine against Iberdrola demonstrates regulators will not accept static personal data for identity verification. Replace security questions with dynamic methods. Document verification procedures with audit trails. Review Article 32 GDPR compliance for all authentication systems handling customer account changes. Establish 72-hour breach notification protocols. The Croatian hospital fine shows that criminal prosecution of employees does not eliminate GDPR breach notification obligations. Unauthorized disclosures by staff constitute personal data breaches, requiring DPA notification within 72 hours and data subject notification without undue delay. Document breach assessment procedures. Review device search warrant procedures. The 10th Circuit's ruling in Armendariz requires particularity and narrow scope in warrants for digital devices. Law enforcement should limit searches to specific timeframes and keywords directly connected to alleged crimes. Avoid overbroad searches that sweep up years of communications. Prepare for FTC surveillance pricing disclosures. Epic petition to the FTC signals coming transparency requirements for algorithmic pricing. Document data sources used in dynamic pricing decisions. Review whether pricing algorithms create discriminatory outcomes. Prepare disclosure mechanisms showing consumers when surveillance data influences prices. Verify automated citizenship determinations. The DHS Save tool's widespread errors demonstrate the risk of relying on automated verification systems without manual review. Election administrators must independently verify citizenship determinations before removing voters or restricting access. Implement due process safeguards for automated eligibility decisions affecting rights. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.